All right, everybody, we got one more minute. Figure all this stuff out. I'm gonna keep muting everybody. And then if you want to ask questions, you'll be able to unmute yourself. But for now, I want everybody muted. All right, everybody, it's 9 o'clock. We're gonna get rock and rolling. Okay, so happy new forms year. We're on the cusp of 2025, and new forms are abound in 2024. Condos, mold, flood disclosures, and a whole lot more. These are the NABOR forms. So I'm going to do a different class on FARBAR forms as they come out. But NABOR has released its 2025 forms. And I'm going to say this a couple of times during the presentation, but you have to make sure that you're using the most recent forms because a lot of law changed in 2024. And we want to make sure we're totally up to date. Now, a couple of rules of the road for many of you that have been on my Zooms before. You can feel free to unmute yourself, ask questions, say something that doesn't make sense. Feel free to interrupt me. Put your thoughts in the chat. I'll be monitoring the chat throughout this process. And of course, because I am a lawyer, first we start off with a disclaimer. I'm giving you a lot of information, new information today, but we do not have an attorney-client relationship. And if you want to have that, you have to contact me separately. A couple people have asked, I am recording today, and I will email this out to people who want it and post it to my YouTube channel later. A little bit about me for those of you that are new. I see a lot of familiar faces, but I see a lot of new faces. So I've been a lawyer for 21 years, and I am a past chair of the NABOR Legal Resources Committee and the current scribe. And so what we're talking about today is directly relates to that. I also serve as a member of the FARBAR Florida Realtors uh, Florida Bar Joint Contract Committee. So I know those contracts. And my bread and butter, of course, is real estate transactions. And for that, we have a title company. And you can reach me anytime at the number here on the screen. It's 239-784-5556 and get really excellent service with our quick, accurate closings. So today we're going to talk a little bit about some of the law changes in 2024. We're going to talk about the sales contract and all the changes, the new addendum for the condominium, the new flood insurance disclosure, the new allergenic mold addendum, and the revised cooperative addendum. I'll start off by saying the sales contract. So the way we did this is I took all the 2022 contract and redlined it versus all the changes in 2023 and 2024. And that's what's going to be released for January 1st of 2025. So make sure that you always use the forms that are dated January 1, 2025. But before we get into that, and then we'll talk a little bit about the as is and the vacant land contract, but those changes are all very similar. But before we get into that, let's talk about some legislative changes. And let me just tell you that your Florida legislature was busy with real estate in 2024. Lots and lots of stuff happened. What I'm touching on today is the tip of the iceberg. Any of you that work as community association managers, as CAMs, or do other property management related things, there's going to be other changes you need to be aware of. Today, we're talking about the stuff that affects the contract. So first off, HB House Bill 1049 created a mandatory flood insurance disclosure that sellers have to make on or before the execution of the property. NABOR and FARBAR have flood disclosure forms for realtors to use, and we're going to talk about that in detail today. HB 1021 says that condo associations with 25 or more units must post digital copies of their documents on their website. And then it talks about all the reports and everything that has to be included. And we're going to get into that in detail when we talk about the condominium form, the new condominium addendum. HB 1203 increased the transparency of HOA documents. Any homeowner association with 100 or more parcels also have to maintain their records on their website. So condos over 25 units, HOAs over 100 units, got to have websites with all their documents on them. This, of course, is super important for you, for those of you who take listings in HOAs and with condominiums, which I'm sure is all of you, uh, because if it's over 100 units or over 25 condos, you can now have your seller go to the website and download all of the required documents and put them in the MLS in the supplemental section of your listing so that your buyer can't claim later, oh, I never got those. So we'll talk about that. Also, structural integrity reserve studies, those are not new in 2024, but the deadlines are coming up by December 31st of this year. Condos were supposed to have their studies done to fund their reserves for major repairs and replacements. For those of you that sell a lot of condos, you know, of course, that this is going on and that special assessments are really starting to rack up to cover the reserve studies. Deficiencies found in the reserve studies is a better way to say that. And so paying attention to your condo documents and your condo questionnaires when you've got Fannie Mae and Freddie Mac loan products, super important. Along the similar lines, the milestone inspection for condominiums. Um, this changed a little bit in a glitch bill. So the deadline for milestone inspections depends on the age of the condo building. It must be performed before December 31st in the year the building is 30 years old and every 10 years thereafter. If a building is 30 years or older before July 1 of 2022, the inspection is due in 3 days. If it's 30 years or older on or after July 1, 2022, but before 2024, you have another year. So for those of you that sell condos, especially those that are older, you got to make sure that the milestone inspections are done. If they're not, then you have to declare they're not done, and we're going to talk about that in detail. Okay, before I move on to the forms, does anybody have any questions on the laws that changed? Okay, seeing none, let's talk about the forms. So give me a second while I switch to PDFs. Okay, everybody can see my screen. Sales contract. I see heads shaking. That's good. That's a good sign. All right. This is the 2025 NABOR Residential Improved Property Sales Contract. This is the main contract produced by the NABOR Legal Resources Committee. And again, what I did is I took the 2022 form, which is the last year we did revisions. We had a few tweaks in 2023. Then obviously we made a lot of changes in 2024. What you see on the screen are going to be red lines. The red lines are the changes, the additions and the deletions. We'll go through them. And again, if you have questions, feel free to unmute yourself and ask questions. So right off the bat in paragraph 1 here, we added solar panels and related equipment to the list of items that stay. You would think that this is automatic because solar panels are screwed to the roof, and if it's screwed or glued, it's a fixture and it stays no matter what. But there was a question about the controls and the internal parts in the garage and the extra stuff. So we clarified that solar panels and its related equipment all stays with the property. You'll notice a few little red lines like this one right up here where we had to fix little glitches. I'll identify those, but not spend any time talking about them. The next change is we added the word identified to parking spaces, garages, cabanas, storage lockers, and boat slips. There's always been a problem in the NABOR form where people want to type in the number of parking spaces offered with the condominium unit instead of the reference as to which parking space goes with the unit. So we tried to clarify that it's not the number of parking spaces that go with the particular unit or the number of garages or storage lockers or cabanas. It's the identifying the unit number of this parking space, the garage, the cabana, or the storage locker, so that when we're transferring title, we know which title to ask to be transferred by the association. We also added defaults here for the initial deposit, and for the second deposit, 3 days to make your initial deposit if you don't add another number in the blank, and then 15 days for the additional deposit if you don't add a number in this blank. So, and this is very important because, as we all know, the NABOR contract says that if you if you're a seller, your only remedy are deposits made. So if your buyer misses the first deposit and the seller gets worried about it, having a deadline of 3 days there means on the fourth day, the seller can go ahead and put the buyer in breach and move the contract along or get the property relisted. Very, very important. Now, probably the most important thing about the changes here of this contract is this right here, the date. 1/1/2025. Please, please, please make sure that your forms are all dated 1/1 of 2025. Don't use the old forms anymore. There's too many law changes that you will get in trouble. For example, with the old condo rules that have changed, and we're going to go over in a few minutes. Things like that. Just make sure you're using the January 1, 2025 forms. They're available on NABOR.com. They're being posted to Form Simplicity and Zip Forms and all the other programs that you guys like to use, which are all great. But please make sure you're using the 1/1 of 2025 form. Okay. The next change is we clarified that as of closing, the buyer is the legal owner of the property and the seller shall vacate and give access and possession at closing. So it used to be that people said, well, I'm not going to give you the keys until I get my money. And you're going to see when we get further down into this contract, we clarified the seller gets their money upon disbursement, which is immediately following closing, but the keys and the access and possession pass at closing. So that's just a clarification.
Hey, Sam, quick question, real fast.
Sure, Darlene.
Going back to parking spaces and how it's a reference to, parking space
Sure.
301. If there isn't anything, you leave it blank, you put it 0. What do you want to see there?
If there's none, I personally like to see NA, but
Okay.
a lot of people just leave it blank.
Okay.
My personal preference is that you don't leave blanks in the contracts because that way it's clear to the judge that you at least thought about it and didn't skip it.
Right. So it's a 2-car garage. You don't put 2.
You would put number 201 and number 202 or whatever the unit number is for the garage, the cabana, the boat slip. Don't put 2 if they get 2 parking spaces. Put the unit numbers of both spaces.
Or a single family home with 2-car garage.
Well, that would be, you would leave that blank. This rule only applies to common elements and common areas, which are more for condos.
Oh, I see what you're saying. Yeah. Okay, thanks.
Yep. Okay. All right, so the next change that we made down here in the financing section, as you know, the NABOR contract after the expiration of the finance contingency period allows the buyer or seller to terminate the contract, but the seller had to provide a statement of Equal Credit Opportunity Act adverse credit action. Well, when Dodd-Frank came along, which is actually in 2010, it shows you how behind this was, there is no longer an Equal Credit Opportunity Act note statement of adverse credit. There are merely statements of adverse credit action. There's a standard form that Fannie Mae puts out that most lenders use, but it's not required. So we took out the words in Equal Credit Opportunity Act and just said that the buyer needs to provide any from the lender, any statement of adverse credit showing that they're not going to get the loan, and then the buyer can terminate. Christine is asking, is this for all forms, single family and condo 1125? Yes, this is for all forms. Every single NABOR form has been redated to 1125. So make sure you're using the most recent forms, Christine. Again, with the date, I'm going to bring this up 50 times. 1/1/2025 is on every page. Okay, the next major change is now, it's always been the case in the NABOR forms that when you had a governmentally imposed lien or special assessment other than a CDD or MSTU assessment, the seller brought it current and paid it in full at closing. Now, buyers and sellers can, in the NABOR form, can negotiate who pays after closing. You pick the box here, seller or buyer. And if the, let me make this so you can see it. If you check the box for seller here, then the seller pays all installments due prior to and after closing. And if there is a restriction by the HOA or the condominium on being able to pay this, or the town being able to pay the special assessment in full, typically that restriction results from the financing instrument that was used to cover the whatever the special assessment is for. Like if you're putting a $30 million roof on a condo building, or a set of condo buildings, and they get a loan and then it's supposed to be paid back over time, and there's a prepayment penalty, so they won't accept upfront payments, then the seller gives a credit to the buyer at closing, and the buyer then just makes their payments going forward pursuant to the association documents. If you check the buyer box, then the buyer just picks up all the assessments that due after closing. Everybody understand that? That's a pretty big change. It's no longer a default where seller just pays everything. Now you have to negotiate it.
Sam,
Yes,
Cindy,
Cindy.
a CDD, how does that work?
CDDs are different. Remember, CDDs are not, there's no actual disclosure required for a CDD. We do have in paragraph 5, the notification of the existence of a CDD, but technically the CDD disclosure is required by contract and not by statute, and those are paid on the tax bill. So they're prorated with the other non-ad valorem assessments. So they're not included in what I'm talking about for special association assessments or governmentally imposed liens. We have a carve out for CDDs right here.
So they
So
don't,
be
because I
careful with
had
your
some,
CDDs versus others.
okay, because yesterday I had somebody ask me, does the buyer pay that? And I said, no.
The buyer pays the CDD due
I
after
mean, the
closing and
seller,
it's prorated.
yeah, and they asked me if the seller will pay it off, and I said, no.
Yeah, that's something you would negotiate.
Dan, can you just repeat what, I mean, not repeat, but just in a nutshell, break that down? So special assessments, you check buyer or seller and they pay it off in full. If they can't pay it off in full, the credit is given from the seller to the buyer. Is that it?
If the seller is to pay it off at closing, but it's not payable at closing due to the rules of the association, then the seller just gives a credit for the outstanding balance.
But we're talking about only on special assessments.
And governmentally imposed liens. So like if you get the Marco sewer improvements, or if you use this in Cape Coral and you got the water district improvements.
Okay, so back to your roof example, then I'm just saying I understand that this is kind of just a little bit different way of doing it, but let's just say the seller says, well, okay, we just got that special assessment. I'm moving away. I'm not getting the benefit of the roof. So I want the buyer to pay. And the buyer's like, well, that special assessment didn't happen during the time that I owned the condo. I mean, that's a huge, like.
Yeah. You got to negotiate it, figure out how much a special assessment is, and go back to each party and figure out who's going to pay for it.
Thank
you. It used to be seller paid in full.
Right.
So now it's a negotiating point.
Right. Thanks.
Yep. Okay. Again, with the dates on every page, please don't forget that. Okay, the next big change is updating title. Somebody dies or something happens to title during the closing process after the effective date, after the initial title search has been completed. If something new pops up on title, then the buyer may perform and procure an updated title and determination of legal access. We call that a title update. And they can then have the seller correct any new title defects. Now, if it's something that the examiner missed during the first title search, then the buyer does not get a second bite at the apple in that regard, only for new stuff, which is typically caused by the seller, like the seller dying or something happening in a probate or with a trust that requires there to be a change in the title. You can do an update of title. The next change is, used to be that any survey in the seller's possession was required to be turned over to the buyer, which is a pain in the butt for sellers and not very helpful to buyers. But now, if the survey has been certified to the seller, then the survey needs to go from the seller to the buyer to save the buyer a few $100s in survey costs. It provided the seller can sign a survey affidavit. The other thing we noted here is that the survey objections, if there's a problem with the survey that's noted by the buyer, it's treated as a title defect, and the seller has to correct and gets 30 days to correct, which can extend closing. This is not really a change, but more of a clarification. Mark, you're asking about whether the NABOR contract is frequently used in Cape Coral. I've seen it once or twice, and when I've written a contract in Cape Coral, I've used the NABOR form. Okay, the next big change, flood disclosure. There is now a mandatory flood disclosure in Florida that sellers have to provide to all buyers on all contracts. So we're going to go over the flood disclosure in a few minutes, but just know that in the NABOR forms, the residential improved, the vacant land, and the as is, you have to provide the flood disclosure form. Buyers should not execute the contract until they have received and read the required flood insurance disclosure. And this is in red in the new contract. The next change here, that's a spelling correction. It's no big deal. Few formatting changes. Okay, this is another big change right here. Not big, but important change. If you get multiple radon tests, you now look at the average. So that when the buyer gets their radon test and it's 12, and the seller gets his radon test and it's 2, well, the average of that would be 7. So you have high radon. But when you have dueling radon tests, you now look at the average. You no longer have to fight about it. I think that's a nice clarification for people. Next up, these are just some grammatical changes, clarifying what the buyer's election is. Not overly important. Just know, of course, that the buyer gets to make an election for inspection items, and this just clarifies what the reference is. Again, clarifying the references. Next big change is uneven or sunken pavers, which were always considered cosmetic in the NABOR contract, are now clearly stated as cosmetic in the NABOR contract. So uneven or sunken pavers are cosmetic. This we had a difficult time defining what a casualty is. So all this red line here is just a rework of the definition of casualty and when it applies. It's not really a change, just clarification that in the event of a firestorm, flood, extreme weather condition, or other casualty occurring between the effective date and the closing date, then that's a casualty. Any loss or damage to the property, including the landscaping, shall be its seller's sole risk and expense. And just as a side reference, this is not a change, but just a note, the seller's sole risk and expense is unlimited liability. And then we also created, you'll note here on line 367 of this form, but it'll be a different line on your forms in form simplicity. We now have standard D3. Standard D3 is the risk of loss provision. It used to be standard D2E. Now we changed it to 3 to make it clearer, more relevant. So that's what you see, these changes are just a renumbering of that. Okay. Now, the seller's instrument and expenses, it has always been a bit of contention, but the question comes up as to whether the seller was responsible to provide management company contact information and required application forms and statutorily required association documents. Now it is clear in the contract, the seller is responsible to provide all current association and property management contact information, any required applications, forms, and all statutorily required association documents. So be very clear about this, because it's always a big fight with everybody as to who's responsible for what. The seller needs to come to the contract with the association information. Of course, the best practice is you as the realtor get this information from your seller, from the management company, however you need to get it, put it in the MLS, and make sure that the buyer signs off on it, the required disclosures or condo doc receipts or whatever else, gets the application as a part of the contracting process so that there's not a delay. Because one of the changes, and I'll go back to the condo change in a minute, one of the changes is that the buyer has 10 days from receipt of the applicable association application forms, not from 10 days from the effective date. So that's a change in the timeline, and the buyer is not later than 5 days prior to closing to get approval. So you need to get your forms, your association documents from the seller to the buyer quickly in the process. That's super important now.
Sam,
Okay,
I have a
the most
question.
major change that we're going to talk about today is, you'll notice here, standard I has been deleted. See attached amendment to contract condominium if applicable. Buyer should not execute this contract until buyer has received and read the addendum to contract condominium. It is no longer the case when you sell a condominium that you can use just the NABOR contract. This is a major change. This was very hotly debated at the Legal Resources Committee. But you'll notice over here, all the condo stuff that was in the contract has been deleted. It is no longer there. You sell a condominium, you must use the addendum. And we're going to go over that addendum in detail in a few minutes. Okay. Before I do that, everybody understand that? You have to have a condo addendum. I really don't want this to become a problem for everybody later, because buyers are going to be getting out of contracts if you don't attach it.
Sam, on the receipt of condo docs, I understand that the buyer does not have to sign the receipt of condo docs.
The buyer absolutely needs to sign the receipt of condo docs. The condominium document receipt process has not changed. It's actually gotten longer. There are more documents that sellers have to provide, but the process of giving it within 3 days has not changed. So be careful. I'm not sure where that's coming from, but let's be careful there, Bob.
Sam, can you go back to that association forms? The buyer has 10 days from receipt.
Yes, right here. Yep.
I didn't get a chance to even read so 10 days from receipt of the association to do what? To
So
sign
the seller is now, this is a great question. I shouldn't have skipped over this so quickly. The seller is now responsible to
Mhm.
get the association application forms from the association and give them to the buyer. And we used to say in the contract that the buyer had 10 days to make application from the effective date. We
Mhm.
now say the buyer has 10 days to make application from the date of receipt of the forms from the seller. So it's even more important that sellers put the application and association documents in the MLS. Otherwise, the buyer gets a free out when they don't get their application done in time.
So 10 days from receipt of all those forms to make an application to the association.
Correct.
Got it. Okay.
Yes. So
Yeah, that's much tighter.
Thank you for slowing me down on that one. That's very important.
Yeah.
And then
okay.
Mark is asking, most agents haven't received the 2025 association budgets for their listing. Mark, that's probably correct. That's another thing that we'll have to talk about is this, the association updates, which they're going to start doing here as they have their spring meetings in January, February, and March. You have to update the MLS. You have to update your forms. And when we get to the condo rider, the new condo addendum, keep calling it a rider, but it's an addendum. When we get to the condo addendum, you're going to see where you need to fill in the blanks for the numbers. And Craig is asking about associations making application. Yes, they have to make application before they have inspection results. That's exactly right, Craig. Okay, and Linda is asking, will the timeline of events be changed to reflect all this? Yes, the timeline of events has already been updated. That's a great question. Thank you.
Sam, is there any security for the buyer having to make applications like that
If they
gentleman?
don't make application within 10 days, they lose the right to terminate.
No, the question is, they're gonna have to spend money to make that application, right?
That's
Some are
right.
higher than others, and let's say the inspection report lets them get out of the contract because it's not good, then they just lose that application money. So every buyer will lose that application money if they can't get their inspections done prior to the application in 10 days.
That's correct. They would lose the application fee. Yep.
Wow, okay.
Yep. But it's always been the case. This actually gives the buyer more time. It used to be the buyer had 10 days from the effective date. And if they didn't make application by 10 days from the effective date, then they lost the right to terminate if they didn't get approved by closing. Now it's 10 days from the receipt of the application form, and that's 5 days prior to closing. So it helps the buyer and it also hurts the buyer in terms of their costs. Will the flood disclosure applies to every property in Florida? Yes. So we'll get to that. Okay. Okay. This is going to be a controversial change, and I'm sorry that I don't have it all on one page, but that's the spacing in PDFs. The timing of seller's receipt of seller's proceeds is not a prerequisite to seller's obligation to vacate the property and give access and possession to buyer once the closing agent has confirmed in writing that the closing agent has initiated the dispersal of seller's proceeds and officially declared the transaction closed. What does this mean? Sellers are always complaining that I'm not giving the keys until I get my money. Well, if the seller wants to come pick up a check from the closing agent at closing, no problem. But if it's an international seller and they're not going to get their money for 2 days or 3 days because they closed on a Friday afternoon and it's an international wire, they don't get to hold up the keys over the weekend. And that was causing a lot of consternation for realtors and buyers and sellers. And so we made a policy decision at the Legal Resources Committee that the keys will be released at closing, and that's clarified in the contract. And this was a close vote, but it did come down this way, and this is what your new contract is going to read. The timing of seller's receipt of seller's proceeds is not a prerequisite to seller's obligation to vacate the property and give access and possession to the buyer at closing. Everyone understand that? Very important. No more fighting about the keys. Okay, Mark is asking, if an agent takes a listing and has a current association documents, it is the seller's responsibility to inform the agent of any change or the obligation of broker to verify there haven't been any changes. Yes, Mark, that's a great question. The seller is obligated to provide association documents, and I would argue updated association documents as they come out. So yes, that's on the seller. Lynn, you have a question?
Yes, good morning, Sam. With regards to the listing agreement, are these types of things going to be spelled out in the listing agreement?
Yes,
So
they
the
are.
seller,
We
the seller knows ahead
clarified in
of
the listing
time?
agreement that the seller's responsible. I copied and pasted this stuff out of there.
Perfect, thank you.
Into there, sorry, from the contract. So yes, the listing agreement, I chose not to bring the listing agreement in today so we could focus on the sales contract and the sales addendums, contract addenda. But the listing contract has been updated for 2025 and it includes these changes. Vanessa is asking, do we need to update existing listing agreements? Vanessa, if you have an old listing agreement pre-October 1, 2024, you need to update it. If you have a 2020 October 1, 2024 listing or later, you should be fine. So that's a little outside the scope, but I'm answering the question because you asked it. Okay. Nancy is asking, do we need to change all existing MLS supplements to be 1/1/2025 forms? So yes, you do. Yes. So if anyone can see the chat, Nancy Bradley's question is a great question. You need to update your forms for 2025. There are additional condominium disclosures that we're going to go over in a second that you have to have for 2025 that are not in your 2024 contracts. Cheryl, I believe that the condo association laws are all in effect, and homeowner association laws for documents are already in effect. She's asking about whether there's a date these associations have to have them. I believe they're already in effect. If not, from October 1, then probably January 1. But I'd have to look at the effective dates to be 100% certain on that. Okay, so you have some new addenda. I'm not going over the compensation and concessions addenda today because I have other videos on those, but we are going to talk about the allergenic mold and condominium addenda. Please note the red line, if fully executed and attached here too. So you can't just attach and check a box or not check a box and sign it. You must check the box, you must sign the addendum, and you must attach it to the contract. You need everything. There's case law that just came out in 2024 that found an addenda was not a part of a contract because the realtor didn't check the box. Please don't be the realtor that forgets to check the box. Check the box for your addenda. You have a lot of them, a lot of choices. NABOR provides a lot of forms. And it's very important that you check the box now because there's some bad case law out there. Okay, last change for 2025 is everything in NABOR is now buyer's broker. No more cooperating brokers, no more selling brokers, and all the other stuff that used to be in our forms. They're all uniformly buyer's broker. Everybody, before I switch to the next form, does anybody have questions on the sales contract?
Yes, Sam, it's Tom.
Hi, Tom.
I had a question. We have a condo listing that was dated August 25th. Do we need to have the seller re-sign a new listing agreement? I mean, I get the
August, what is the date on the listing contract? Not
August.
the date they signed it, but the form date at the bottom. Check that. And if it's after, well, if it doesn't have the new, if it does, I don't even know the dates. I don't have it memorized. But if it doesn't have the new language about commission, the new commission structures, and no co-brokes without seller and buyer permission and all that, then you got to get an updated one. Yes.
Okay, no, we have that one. So
Then you're good.
okay, thank you.
Lane, you have a question?
Does this apply to rental listings as well?
Does what apply to rental listings?
All of these changes? So if I have rental listings in
No,
NABOR right now,
these are for sales transactions. Sales transactions
Okay.
that you're saying. So the condo and flood disclosures are sales transactions.
okay,
All right. So let's go next. Before everybody get they're good with questions. Okay. Let's talk about the condo rider. This is a brand new form, so I don't have a red line because there is no changes from 2024. This is brand new for 2025. This contract, this addendum to sales contract condominium is absolutely essential. You must, if you sell condominiums, understand this form. I will happily take your questions As many as you have, call me, text me, email me, or we'll talk about it today. But this form is super important now, again, because there is no condo disclosures in the sales contract anymore. So if you sell a condo, for every single condo that you sell, you must have this form filled out. If you're under contract, I suggest that you get this addendum attached to your sales contract by January, as of January 1, just to be clear, because there's so much new stuff. So in red on the new form, this addendum is required for use with the Naples Area Board of Realtors sales contract when the property is a condominium. Failure to include this addendum for a condominium could result in a contract that is voidable by buyer prior to closing. That's a very long way of saying if you don't use this form, your buyer can get out. So you put your seller information, put your buyer information like you always did, you put your property address like you always have, and then you get into what the form says. The property includes the unit being purchased and an undivided interest in the common elements and the pertinent limited common elements of the unit as specified in the declaration of condominium. The property is subject to rules and regulations of a condominium association under Chapter 718. And then this is the list of 9 documents, no longer 6 documents, now 9 documents that the buyer is entitled to by statute. I'm going to say that again. 9 documents the buyer is entitled to by statute and by contract, because we have the governance form in there. These are the declaration of condominium, the articles of incorporation, the bylaws and rules. Note here, annual financial statement and annual budget. So you need both. It's no longer just the financials. You must include the budget. So somebody in the chat earlier asked, how do I get my updated budget? You're going to get a new budget when your association meets in the first quarter of the year. You need to provide an updated budget and you need to update your MLS. Please don't leave the old budget in MLS and give your buyer an out. If you have the listing, you need to be on top of your listing and you need to get the new budget when it comes out. Then you've got your inspection milestone reports, if applicable, your structural integrity reserve study, if applicable, your turnover reports, and your frequently asked questions, your governance form. All of these are called the association documents in this new form. Now, this form is actually quite confusing because, and Linda, I'll come back to your listing agreement question in a minute. Right here. Buyer, by execution of this addendum, hereby requests a current copy of the above referenced association documents, which seller shall pay for and provide at seller's expense. So right here in the form, the buyer requests that the 9 documents be provided to the extent that they exist. And then when you go down here, and we're going to go back and forth a little bit, you will see the buyer hereby acknowledges the buyer has been provided a current copy of the inspector prepared summary of the milestone reports and so on and so forth. Why do we have both of those in this contract? I'll tell you why. The legislature made a mistake. They used an and when they should have used an or for the disclosures. We're working the reptile section of the Florida Bar and Florida Realtors and everybody else is working to get this fixed. So this form is going to change again. But for now, you will note there's an inconsistency in the form on purpose that you will have to explain to your customer. So they will explain that there's a representation they've been provided the current copy, but also that the agreement is voidable if they don't get the documents and they have 3 days to review them after receipt. So that's why, for those of you that may have already seen this form or are going to read it now and ask me that question, I want to head it off. There's a statutory glitch. We have to deal with it. So you're going to have to explain to your customer that they need to get these documents. Okay, back up to here where we were. So the buyer requests a current copy of the association documents. Then this is the good old statutory disclaimer that you're used to in the standard NABOR contract. This just says that if you don't get the documents until you get 3 days to review them after you receive them, and you can terminate your contract, and it's an unwaivable right. The buyer gets 3 days to review the condo docs, no matter what. That hasn't changed. It just increases the number of documents that they're entitled to receive.
When
Now,
does the time start? If
from
they're in
when
the
the
MLS?
buyer receives the documents. So you have to get as long as you always did, Bob, you've got to get the articles, the budget, the statement, the financial statements, the frequently asked questions, all the documents listed in this section here have to be provided. And until they are provided, the buyer gets 3 days to terminate. Okay. Natalie is asking, should they sign their receipt even though they haven't received? You have to sign the addendum, but you should not sign the receipt, Natalie, of documents until you actually receive them. Then Cheryl, you're asking a great question about the milestone inspections. The answer to your question is yes. Not all condo buildings have to complete milestone inspections, but here's the rub now with this new form. The seller is going to have to prepare this form for the buyer to sign because the seller must answer these 6 questions. I'm going to put them in red so you see them clearly. The association is or is not required to have a milestone inspection as described in statute 553.899. If the association is required to have an inspection, the association has or has not had the milestone inspection. These are disclosures that the seller has to make. There are 3 of them. There are 6 questions that have to be answered. There are 3 disclosures. The next one, the association is or is not required to have a structural integrity reserve study. If the association is required to have a structural integrity reserve study, the association has or has not completed a structural integrity reserve study. So that's important. Whether they've done these or not, they must disclose. If they're required to have them, then they must disclose whether or not they have them. And then there's the turnover report. The association is or is not required to have a turnover inspection report for a turnover inspection performed on or after July 1, 2023. That's for new condos. If the association is required to have a turnover inspection report for a turnover inspection performed on or after July 1 of 2023, the association has or has not completed the turnover inspection report. So you can see, the seller must make these disclosures at the time of contracting. Whoops, fix that, sorry. At the time of contracting. So the seller needs to know this information and fill it in, and you need to put it in the MLS so the buyer can sign. Barbara, you have a question? Yes, ma'am.
Yeah, hi, Sam. I think other people have this question too. I'm not familiar with turnover inspection. Can you briefly explain what that is?
I can only briefly explain it because I only partially understand it myself at this point. But essentially, if you have a new condominium after July 1 of 2023, there is a report, a turnover inspection report that talks about the condition of the condo building. And that is like the landscaping is completed, the structural work is done, whatever is done at turnover, that's got to be completed based on the developer's agreements. You need to put all that in, you need that report to be provided to the buyer. Does
Thank
that
you.
make sense? Christina, you have a question?
Yes, Sam, in this particular section, normally we do a lot of hand holding, or, we take the reins and we take care of all this by calling. Should we be, because the seller is having to check all this, is this solely, do you recommend us just saying, no, this is your responsibility to find this out, not, because they have to check
So
it.
that's gonna be a broker question, but my personal feeling as an attorney who deals with liability issues is that you as a realtor don't want to fill this out. You want your seller to fill this out.
Right. I'm not even, of course, I would agree with you there, them filling it out, but I'm talking about them just getting the answers. Or if we called and got the answers, is that something that the HOAs will be actually sending us in writing or just?
You need to have a cheery disposition and a healthy ability to BS the management company if you want to get this information out of them, I think is the answer to that question.
All right,
And I
thanks.
say it tongue in cheek, but only because even, we send all the management companies cookies and are nice to them and are trying to get the information from them, and they still don't know it or are unhelpful. And that's no fault of theirs because they're dealing with condominium manager or condominium presidents who don't fully understand what they've got to do. It's a very complex task, but somehow, as the realtor trying to make a sale, you have to make sure that your seller gives the correct information to the buyer or the buyer gets out of the contract. So I guess the short answer is check with your broker as to whether they want you procuring this information from the management companies and from the associations. I'm going to guess they want the seller to fill this out and not you, but that's going to be a broker level decision. Okay, so and let me go through some of these questions. I see a lot of them. I've gotten a little bit behind. All right, so on the addendum, there should be 9 or 10 check marks. Yes, on the association document receipt, Christina, there are now check marks for everything. Charlene, I answered what a turnover report is. If the milestone inspection shows a defect that was corrected, is that to be provided also? That should be on the milestone report, Colleen. Natalie is asking, should they sign even though they've not received? You should sign the addenda, but not the receipt. I think I answered that one. And yes, Cheryl, the milestone inspection report is for 3 buildings, 3 or more stories, but you still have to make the disclosure that it is not required. So you check the box for not required. Received can also mean they're available on the MLS, right? No, Craig, that is incorrect. The buyer must have actual receipt of the documents. That's why the condo doc receipt is so important. Just because you post to the MLS doesn't mean that the buyer actually got them. If the buyer's realtor gets them and does not deliver them to the buyer, there's case law that says that that does not count. The buyer individually must receive the condo docs. So be super clear about that. Vanessa, I absolutely recommend that you press your sellers to obtain all these documents, chase them down, get them, make sure that they're correct. I'll tell you this, by the way, everybody, if you need help getting the recorded documents, that's going to be your bylaws, your declaration, and your articles of incorporation, and sometimes your FAQs if they're recorded, I can get those for you for free. So just give me a call or email me your address, the complete address, and I'll get you the recorded documents. That is not all of the documents, however. That is part of the documents. That's the most recent recorded stuff. If you still need the budget, the financial statements, the FAQs, and the governance form, and the reports from the association. Okay, Mark is saying, I'm guessing every seller should have an attorney explain. Yes, you should have an attorney explain the implications of these documents. Yes. Anita is asking if a condo was built in 1970, then their milestone report is due in 3 days. Anita, if you have a listing from a 1970 building, it was due to have their inspection report done by December 31 of 2024. Okay. Natalie. Yeah, Natalie, I understand why it's going to be confusing for buyers, but both disclosures are in here. So, and I think a court would easily say that if a buyer didn't get the documents, then the buyer would be able to get out of the contract.
Hey, Sam,
Yes.
When it
Bob.
comes to the 3-story determination, if you have a condo that's on the ground level and the condo that's above it is one condo, but it's 2 floors, does that constitute a 3-story building?
Only if it's over parking. If it's 2 stories, you're good.
Yeah, there's attached garages.
But I guess what I'm saying is you have to look to the structure itself, not to where the condos start. If it's 3 stories tall, but the first floor is parking, and then it's a 2-story condo over parking, that's 3 stories. If it's 2-story condo sitting on the ground and parking's in front or next to it in a garage or something, that's 2 stories, you're okay.
Yeah, there's the first unit is a ground level with attached garage. The unit above it is a 2-story condominium with an
Oh,
attached
that's
garage.
3 stories. Yeah,
That's
that's
3
3
story,
stories.
okay.
That counts.
Even though it's only 2 condos.
Right.
Okay,
It's really
thank
tough
you.
to have 2 condos in an association. That's a weird association. Okay. All right. So let's talk about this confusing language one more time. So the buyer hereby acknowledges that the buyer has been provided a current copy of the inspector prepared summary of the milestone inspection report, a copy of the turnover report, and a copy of the structural integrity reserve study, and they get 3 days to review and terminate if they don't like it. This is obviously very confusing. Let's put this language in here. We have to put it in there. And then the very next paragraph says that this agreement is voidable by buyer by delivering notice of intention to cancel within 3 days if they didn't get all those reports. And unfortunately, these 2 disclosures in bold capitals, again, it's a statutory glitch. And I don't have any discretion here. I had to put them both in the addendum. Hopefully that will get fixed and we will take the first one out. But until that date, be advised that you need to explain to your customer that if they don't get the documents, they get 3 days to terminate. Once they get the documents, 3 days, and then they lose their right. And this is the same requirements for FARBAR. FARBAR actually, Becky is asking about FARBAR. FARBAR has always had a condo rider. So this is a new thing for NABOR, makes us more like FARBAR. Okay. Keep going on the disclosures. Christina's asking about when this might be changed. The legislature meets for 60 days, like March, April, and hopefully it'll get done in that time period. It should be a pretty simple fix to change an and to an or, but hopefully it'll change quickly. I don't know the details of that. Okay, the next section of your disclosure is multi-parcel buildings. And I'll tell you right now, I don't know of any multi-parcel buildings in Collier County. If you have a unit where a portion of the building is a condo and the other portion of the building is like a hotel or office space or something, this does not, Bayfront does not count, by the way. Bayfront is 2 associations. But if you had multiple elements within a single building, then these disclosures are provided. Again, I don't know of any in Collier County, so I don't know that this is going to be too useful, but it is required to be provided. So we put it in the new condo rider.
Pam,
Cheryl is asking, is it correct that all the requirement isn't fulfilled until all documents have received, then the 3 days? That's exactly right, Cheryl. That's exactly correct. Okay, next parts of this 3-page document. Up next is the right of first refusal. You're asking about mixed use. Marissa, mixed use condos are not multi. This is if you have like a hotel in the building, in the condo building, or something like that, or offices within the condo building that weren't part of it. And like I said, with like something like a Bayfront or what's the one on Vanderbilt? I never go to. Whatever that is up there. Those places, those are mixed uses, but they are Mercado. Thank you.
Mercado.
Those places are mixed use, but they are not multi-parcel. Edward, do you have a question? Okay. Yes, I was thinking Mercado. All right, so the next sections of this are the right of first refusal. If the association or the membership of the association, there are two options here, have a right of first refusal to buy the unit. Say you come in really low and they don't like the price, so they're going to take it from you. The association may have that right in the condominium declaration. Then the seller has 5 days after receipt. The seller has to submit the offer to the association. And then they have 5 days after receiving the decision, they must give notice so that the buyer can terminate and get their deposit back. Excuse me. Okay, up next is hazard insurance. Many lenders want to see the hazard insurance. So we have a provision in this condo rider now that says that the buyer is entitled to copies of all the insurance policies covering the condominium property, the association, and the unit. We also have a provision that all, Christina, yes?
I'm so sorry. I totally got lost on the rights of first refusal. You're saying that if a condo is going to be sold to a buyer significantly under ask or what have you, that now the condominium association has the rights to buy it first?
No.
Oh, okay.
Only
I'm like,
if
what
it's in the
happened?
condominium documents that the association has a right of first refusal would this apply. So you have to look in your documents and see if there's a right of first refusal. And
Okay,
if there is, then the seller has to submit the offer, the signed contract, the fully executed contract to the association. And then the association makes a decision whether they want to exercise their right. And there's a huge court case going on that I'm involved in Collier County over at Naples Bay Resort with a right of first refusal. It's a big mess. And so this provision clarifies that when the buyer and seller need to give their information, and this is the same as FARBAR. Okay. Assessments and fines. All assessments levied by the association shall be brought current by the seller, and the seller has to pay all fines imposed by the against the property by the association as of closing, and any fees association charges for assessments or like estoppels and things are all paid by the seller. Vanessa is saying entitled to doesn't mean the buyer must provide those docs. No, entitled to means the buyer must receive those docs, Vanessa. Okay. This is very important for you as the broker. This is in the statute, so I put this in here. The listing broker and buyer's broker are not responsible for errors or inaccuracies contained in the documents. This is statutory. We protect you, the realtor. We're a trade association. They are a NABOR. They want to protect you. So that was very important add, I thought. Okay, next up, buyer and seller sign. Note that says incorporated in the contract and made an integral part thereof. So this rider, this addendum is part of the contract. You sign, and that's your addendum. However, there's more. If your seller is so inclined, we've now provided a space for the seller to give the frequency and amounts and payable tos for the association assessments, fees, and other charges. This is not part of the contract, although I could argue either way that it is or is not. If you make a representation, I strongly suggest that you make sure it's accurate. And when I mean you, I mean your seller. Make sure it's accurate. If it's not accurate, you run the risk of a buyer saying, well, you made a disclosure that's inaccurate, I'm not buying the condo. So be careful there. But you do now have a space in the addendum to put the amount, the frequency, and who receives the association fees, assessments, and other charges. Excuse me. And you have a spot to put the contact information for the association and the management company. Cheryl, yes, you can leave it blank. I wouldn't. I would try to get the information, but you can. Marla is asking whether the association right of first refusal could be a checkbox. We thought about that, but we thought it'd be easier to do it this way, Marla. So it just says if there's a right of first refusal, then the buyer can get out if the association exercises. And Darlene, you are absolutely correct. This is for condominiums only. Please do not use this with HOAs. Just like you would not use an HOA disclosure with a condominium, you would not use a condominium rider, a condominium addendum with an HOA. So don't mix those up. That's a great question.
Sam,
Yes, Cindy.
I'm coming across a lot of this, the polybutylene again. Is there anything that we have to disclose? This,
Well, polybutylene is not a defective item under the NABOR contract. So no, you would not have to disclose the existence of polybutylene. And if polybutylene existed in the unit or in the association, but was not leaking, then there would be no right of repair or replacement. I know that comes up a lot. I know you and I've talked about this in the past. It's just not defective. And I know I
Okay.
understand the insurance requirements, but the contract says that the buyer is responsible to investigate and get in the insurance requirements. So this buyer needs to ask, is there polybutylene in here? I've got to get insurance. And that's a
Okay.
question the buyer needs to ask up front.
Okay.
Yeah. Terry, do you have a question?
Nope, sorry.
Did you have a question?
No.
Oh, okay. I thought you were muted. All right, Bob is asking, does the seller have to give their insurance policy plus the condo association insurance to the buyer? So Bob, if asked, upon buyer's request, right here, upon buyer's request, seller shall provide a copy of the insurance policy. So if asked, you have to provide it. Okay, Nancy is asking, several listings where the association had their annual meeting increased their fees, some as far back as October, and the listings have not been updated. Is there a deadline to update the listing? It's an immediate deadline, Nancy. It's an immediate deadline. If you provide bad information, you run the risk of being nailed for malpractice. So if you know your association updated their fee schedule, I would update this. Sharon, we are working in NABOR. They are working to get this. I keep saying we, they. I'm not doing it. They are. They are working to get this into app files as quickly as possible. I know that the management of NABOR has already submitted all these forms and working with the vendors to get it into app files and form simplicity as quickly as possible. Okay. Natalie, if your client is not carrying insurance, then you don't have to provide it. Okay.
Sam, quick question.
Yes.
On the fee disclosure in this addendum. If we have an HOA and a condo fee disclosure form already, if a buyer signs this, does that eliminate the need to do the other
Remember, we're
form?
talking about condos only, Tom.
Yeah,
So
for the condo, right?
the buyer should not be provided an HOA disclosure for a condominium unless the condominium is in an HOA.
Right, but I'm saying if they sign this addendum, do they still need to sign that other condominium fee sheet?
You mean the worksheet the NABOR provides?
Yeah, it's a worksheet and
Yeah,
a
that would no
disclosure.
longer be required. We took this stuff right off the worksheet.
Okay, but if they don't fill out the fee disclosure, the other form is required.
It's not required, it's a good idea, but you don't
Okay.
need it anymore because you can put it right on this form.
Okay, thank you.
Yep. Yeah, so the old worksheet that NABOR provided that nobody likes to use because the brokers don't like, is no longer required for condominiums. You wouldn't need, it was never required. It says it's not required right on the form, but it is no longer really needed for condos because you can put your information right in here. However, again, I would argue it's possible that you've incorporated into the contract and made a representation, even though it's below the signature line. So maybe that worksheet's not a bad idea because it's a separate form. This was a big conversation we had at Legal Resources, and this is how we turned out. Okay, other questions about the condo rider? Susan, yes, if a condo is located in HOA, you need this form. Every single condo from 1/1/25 must have this form. Anita is asking if a condo was built in 1970, when's the next milestone due? I think I answered this one. It's due in 3 days.
Sam,
Okay. Yes.
Sam, I'm
Yes, Cindy.
closing 2 deals, the 9th and the 29th. Does this form need to be attached?
You are already under contract? Yeah, everything
Yes.
after 1/1, everything after 1/1, you have to disclose, you have to put these disclosures in place. Yes,
But I'm already at contract,
that
so,
doesn't matter.
okay, so I need to, okay.
Yeah. Yeah, that's a good question. Okay. Up next, allergenic molds. So there is a provision in the sales contract that says, can everybody see the allergenic molds, by the way? Make sure that it changed correctly. Okay. So there is a provision in the sales contract that says that allergenic molds like Penicillium aspergillus are not defective items. However, as many people know, there are people with mold allergies that are very sensitive, and even an allergenic mold could cause them a problem. So one of the questions you need to ask your customers, because they're buying a swamp, is, do you have a mold allergy? If they answer yes to the mold allergy question, you should consider using this new addendum to sales contract, allergenic molds. And what it does is says that if you've selected paragraph 8A, which is inspections in the standard NABOR contract, and you want to make allergenic molds a defective item, then you would go ahead and select this addendum, and now, ta-da, allergenic molds are a defective item if agreed to by the seller. Questions about that? Okay, I see another question about condo writers. Marissa is saying yes. So my understanding, Marissa, is that you must get the condo writer signed by 1/1 of 2025, and you do have a 3-day right to terminate. Yes, because those reports are due as of December 31 of 2024 for the inspections, and they were due last year for the reserve studies. So you have to have this in place. Yes. So I'm sorry, that's gonna make a lot of people upset, but that's the way it is. I didn't write the law. Okay. Up next, we talked about the flood insurance disclosure. This is required now due to recent and for all properties, not just condos, all properties, you must now do a flood disclosure. Um, Read here, due to recent amendments to state and federal law, flood insurance premiums and homeowners insurance premiums may increase, in some instances increase substantially over previous premiums charged. As a result, buyers are advised not to rely on current premiums paid for insurance as a basis for buyers' premiums. Prior to entering into the sales contract for the purchase of properties, you should consult with an insurance specialist. And then the seller has to make additional disclosures. Flood insurance. Homeowners insurance policies do not include coverage for damage resulting from floods. Buyers encouraged to discuss the need to purchase separate flood coverage. And then you have to make these disclosures. This does not apply to vacant land, I'd say. So this is for properties. For built properties, structures. Seller has or has not had a claim for flood damage. Seller has or has not received federal assistance for flood damage. And then we define what flooding means, which is what you think it means. Overflow of inland or tidal waters, surface runoff accumulation, sustained periods of standing water resulting from rainfall. But the seller must make these disclosures before it's sold. No, it's by unit, Christina. So if you have a second floor unit, then you wouldn't, excuse me, you wouldn't have to you would say you have not made a claim because this applies to the property, not the association. You understand that? Lynn?
Yes, thank you.
If we already
you have a
have
question?
this, if we already have this flood insurance disclosure executed, does it have to be re-executed because there's a
No,
new
no,
date at
if
the
you want,
bottom?
this is new. This came out a couple months ago, but
Right,
I'm just updating because the contract changed, so I'm just updating people. So if you've already done this, you're fine.
okay.
Okay. Other questions about flood? Well, and I'll take questions at the end if you have more condo questions, but I do want to get through the cooperative one next. All right, so we don't have a lot of cooperatives in Lee and Collier County or Charlotte County because this contract is good really throughout Florida. But I just want to clarify, I don't have a red line of this, but it is very similar to what we just discussed for condominiums. You've got milestone inspection reports, structural integrity reserve studies, and turnover reports that are due for cooperatives as well. So the seller has to make the same disclosures related to whether they have it, if they've got it, is it, if it's required, is it done? Do they have the do they have to have an instructional integrity reserve study? If so, is it or is it not done? And the same for turnover. So I just want to point that out in the cooperative realm as well. Okay. With that, I believe that I've covered all of the documents I wanted to cover today. Yes. And so I will take all of your questions. We've got at least 15 minutes. I can stay a little longer if needed, but go ahead, Lynn.
Going back to the allergenic molds addendum,
Yep.
when is this required or used?
It's not required. It's simply an option for a buyer who's sensitive to mold and wants to make allergenic molds a defective item under the contract. They can use this addendum to make allergenic mold a defective item where it would not otherwise be. It's not a required form at all. It's not like the condo rider.
So buyers have to know about this.
So buyer, you should tell the buyer, say, hey buyer, are you sensitive to mold? Yes. Allergenic mold exists in Florida as a matter of course, because we live in a swamp. However, if you want to test your unit for allergenic mold and make it a defective item, we're going to use this rider, this addendum. Yep. Other questions? Liz, if an insurance company says polybutylene is not acceptable, is that permissible out of the sales contract? No, it is not. Polybutylene is not a defective item, I would say. Other questions?
Sam.
Lynn, do you have another question? Christina?
So, to go back to that one form, it was an addendum on the condo about putting the prices in for what the
There,
HOA fees
at the
would
bottom
be.
of the fees, yep.
Yes, so that is not in lieu of, or is it in lieu of the HOA disclosure?
It has nothing to do with the HOA disclosure. This
Nothing
is
to do with
strictly
it.
for condominiums.
Okay,
So if you have a condominium inside of an HOA, you're going to give an HOA disclosure in addition to attaching this addendum to the contract.
but those would, I don't know why I'm still just, maybe I didn't have coffee, enough coffee, but that would not be like, okay, I know the HOA fees for, the main association or the, the subdivision of the main HOA, but this
Sure.
is something separate that a condo would also charge, or this is?
This is what the condo would charge, yes. So what you're looking at on your on the screen here is what the condo would charge. You still need the HOA disclosure. So say, for example, you're selling up in Vanderbilt Country Club, where they've got the club and the HOA and the condo association and everything else. You would use this condo form for the condominium that you're selling. Then you would attach the HOA disclosure for Vanderbilt. And then you would write in this fields down here that you see on your screen now, what the dues are for the condo and the club and everything else you want to include.
Okay, thank you.
Yep. So I apologize I know it's confusing between the difference between HOAs and condos. We got to keep them separate in our minds.
Sam, it's Colleen. Where would we disclose? We're seeing on the MLS a lot of these, they call them transfer fees or capital contributions.
This is where I put them, right here, what you see on your screen.
Okay.
And
Thank
you can
you.
put it in there, $1,000 per one time payable to Association X. That's exactly what I'd put on there. Edward, do you have a question?
Yes, Sam. If we can go back to the milestone study, is there a distance from the beach on these condominiums that are required?
It's 3 miles. It's 3 miles.
3 miles. Thank you.
Yep. So if you are 2 miles from the beach, you would need to have a milestone inspection, and you would check the box is required. If it's 3 stories or more, check this one right here is. And then you would check whether they have or have not done it. And many associations haven't done it. And that just creates a problem until it's done, and they need to do it. It's 3 stories or more, any condo over 30 years and 3 miles of the beach.
Thank you, Sam.
Yep. Colleen?
I just was wondering about the flood disclosure. We're talking about if the structure floods, not the property.
Yeah, you need this disclosure for every property now. It's in the contract.
Or
You need it
before.
for every
Actually,
for every
she's
property.
saying 2 weeks. So yeah,
Say that again.
I would say what date is the 15th on?
Oh, Debbie's not. She's unmuted. All right. Sorry. Go ahead. Ask your question again about this flood disclosure.
I want to make sure that it's for the structure, not just the property. You're
Well,
talking
won't
about
need it.
has
You don't. My understanding is you don't need this for vacant land. So but you need it for a condo or a home or a single
Okay,
family.
thank
Other questions? All right. Thank you all very much for your time today. If you need anything from me, you know where to find me.
Sam, one question. Hi, it's Birgit. Darlene made a comment that HOA disclosures do not need to be disclosed. Can you please touch on that? Because I think that's a very huge deal that you mentioned.
No, Darlene, I see it out here in the chat. Yep. Sorry, it's doing a lot. But yes, sorry. Yes, the HOA fees must be disclosed on the HOA disclosure form, which is a statutory form. This is separate from the condo rider, the condo addendum, where remember, condos, you don't have to disclose the fees. They're in the frequently asked questions document. You have to provide the frequently asked questions document. It's a different form for HOAs than condos. And if you're in a condo in an HOA, you need both. If you're in an HOA, you need the HOA disclosure. If you're in a condominium, you need the condominium addendum. So yes, thank you, Birgit. That's super important to get that right. And I'll get the recording out pretty quick, Mary. I'll get this out here and give me a couple hours, maybe tomorrow.
So Sam, it used to be an HOA disclosure summary.
That still exists.
Right. And does that talk about the fees, or it just says?
No, the HOA disclosure summary talks about the assessment and the special assessment and the rec fee. That's those blanks on that one form, which I don't have handy.
No, I can't remember it either. And then separate to that is this condo disclosure now that seems
Yes,
to
the
lay out
condo
all.
is totally separate from the HOA. Yes.
Right, but you would need both if you're at, let's say, the Vineyards, and there's an HOA plus a master HOA plus condo association.
Correct.
Okay.
You're absolutely right.
And then if somebody's worried about polybutylene, you can use a blank addendum. So if you have a buyer who is worried about poly B, you can say, hey, if it is discovered at the inspection, this buyer wants that to be considered a defective item. Can you use it that way?
You can do that. Yep.
Okay.
Sam, can
Lynn, you have a question?
I have a question.
I'll call on it. Lynn, go ahead. You're at the top of my list. Go ahead.
Okay, thank you. When are you doing a FAR class?
I'm working on it. I haven't put together yet. FAR forms are a little behind.
Okay,
So it depends on them.
so
Angela?
it's not going to be January 1 also.
No, it's not going to be January 1.
Okay, thank you.
Angel?
I just have one quick question. Go back to the milestone. I have a condo I'm getting ready to list. It was built in 70s. 2 stories.
Within 3 miles of the beach?
Yes, that's my question. It's 2-story within 3 miles of the beach.
Well, is it 2 stories over parking or just 2 stories?
It's 2 stories.
Then you don't need it.
That's what I figured. Okay, just wanted to clarify it in my head. Thank you.
Yep.
Sam, I have a quick question about structural integrity reserve study. What
Yes, ma'am.
condos have to have that?
Say it again.
What condos need to have the structural integrity reserve study?
I'm pretty sure it's every condo has to have a structural integrity reserve study. That's different than the milestones.
Oh, it isn't subject to height?
I'll double check that. I don't think, I thought there was a glitch bill that fixed that. So that last year, and so there is no, it's required for every condo.
Hmm.
I'll double check that. I'll send an email on that. I actually have an email on that. I will double check it and I will send it out again.
Thank you.
All right.
Sam, I had a recent sale in Bridgewater Bay where there is the master and then the sub, right, on the HOA fees.
Yeah.
And I was representing the seller. We had an incident where, some of those forms, you were not supposed to use the same form to disclose both the master and the subdivision.
Right. You should have two
Right.
HOA disclosures. Right.
Right. So the second one, so we disclosed the primary, the master. Then the sub one, I was told, we didn't disclose. So then there was an argument between the buyer and an attorney, and the attorney did say, we do not need to disclose that HOA fee. That is up to you to find out. Just what Darlene said. So
That attorney is not correct. The statute is abundantly clear, and if I had an extra time, I'd pull it up and show it to you. But
okay, well, that's interesting.
You have to provide for each association.
Okay, thank you.
Yep. Charlene?
You answered my question about the structural integrity reserve study.
Okay, Bob? Bob, do you have a question? Okay. Anybody else? Mark is saying, does every condominium association has to provide the FAQ, Mark? Every condominium, not homeowners. HOAs only provide the disclosure. Condos provide all the documents, only condominiums. Okay, other questions? Anita?
What document shows where spaces are attached to a condominium? Is it the deed?
Are you talking about where you can find the parking space information? It's either in an assignment that the association provides or it's in the deed. It could be in either place.
Okay, thank you.
Yep.
I'm sorry, I just want to circle back to the 25-year milestone for condos that are 25, excuse me, that are.
The statute, I'll double check that as well. I'm pretty sure that statute is all condos, that's 30 years. Within 3 miles.
I thought I saw something in the document here in the sales contract, addendum to sales contract, that if it's within within 3 miles from the coast, it's 25 years. So then, and then 10 years thereafter. So I'm about to list one shortly, and I just want to make sure I have it all correct.
Let me pull up my, I have a writing about this that I made. I've got a chart. Let me pull that up and I'll come back to you. Let me write that down.
Thank you.
Other questions? All right. It's 10:28. I promised that my staff that I get out of here by 10:30. So thank you all very much. I appreciate you. Have a happy new year. And I'm around for questions, text, call, or email.